Hello, we will be reviewing a case study on the collapse of Terminal 2E at Charles de Gaulle Airport in Paris, France that resulted in the deaths of 4 people and injuries of 3 others. The Charles de Gaulle Airport is the largest airport in Paris and the second busiest airport in Europe. Terminal 2E was intended to lift the Charles de Gaulle Airport above Heathrow and Frankfurt as the number 1 airport in Europe. Its massive size of 220,000 square meters had been projected to carry 11 million passengers a year. This compared to Pearson's total of 80 million passengers a year. During the collapse on May 23, 2004, a large piece of the roof measuring 20 by 30 meters fell, as the concrete cracked from being punctured by its metal supports. The investigation of the collapse showed that the metal supports of the middle layer were too deeply embedded into the inner concrete shell. This compromised the integrity of the concrete, and due to rapid temperature change, the contracting and expanding steel caused the blocks to crack. This major design flaw ended tragically, with 4 people dead and 3 injured. Luckily, the collapse happened on a Sunday of a holiday weekend, or casualties could have been much greater. The terminal was designed by French architect Paul Andrew, who has a history of failed designs, including a collapsed terminal in Dubai International Airport in the same year. Taking an ethical look at the case of the Charles de Gaulle terminal collapse, we can find multiple issues as reference to the Professional Engineers of Ontario Act. Our focus here will be on 3 sections. 77.2i. A practitioner should regard his or her duty to public welfare as paramount. 1 week before opening the terminal, it failed a safety inspection due to a chandelier falling from the roof. The terminal was not given a secondary design inspection, but rather was rushed to opening. 77.1 III. It is the duty of a practitioner to the public, to his or her employer, clients, other members of the profession, and themselves to act at all times with devotion to high ideals of personal honor and professional integrity. ADPI did not report the errors to the employers that caused the design to fail. This goes against their personal integrity and honor. 77.1i. It is the duty of a practitioner to the public, his or her employer, clients, other members of the profession, and themselves to act at all times with fairness and loyalty to the practitioner's associates, employers, clients, subordinates, and employees. ADPI was not providing quality professional and engineering work, nor to the employer, as the French government and civilians had suffered from the practitioner's failure in the practitioner's duties. These ethical issues could have been handled in any one of the following 3 ways. Number 1 has them doing exactly what they did, not informing the employer of issues with design and offering no further investigation into the failures of the design prior to opening. This resolves no ethical issues. An alternative to this would have ADPI notifying their clients that the terminal design had failed the safety inspection. Here they would be expected to disclose to the client the problems with the design and the options for improving. A third alternative would be having a third party review the technical designs as well as the structure of the terminal, thereby confirming the safety and stability of the design.
The ethical decision that should have been made during this case was decision alternative number 3. ADPI should have notified the employer about their concerns about the structure after the inspection. Further analysis should have been conducted to ensure the structure was stable regardless of the time constraints and pressure to open the terminal to the public on schedule. Next, we will analyze the tragedy of Terminal 2E in a legal perspective. The most relevant example of torts law that relates to our Terminal 2E collapse is the Donahue v. Stevenson case. Mrs. Donahue drinks a bottle of ginger beer containing a dead snail given by a friend. Mrs. Donahue falls ill and pursues a lawsuit against the manufacturer, Mr. Stevenson. There is no contractual relationship between Mrs. Donahue and Mr. Stevenson, but the court decision in favors Mrs. Donahue. Reason being, Mr. Stevenson fails to provide a duty of care to Mrs. Donahue, as well to the consumers of his product. The plaintiff are the family of the victims from the events of Terminal 2E. There contains multiple tortfeasors in this case. However, the principal defendant is the architectural and engineering company, Aéroports de Paris Architects and Engineers, also known as ADPI. The plaintiff may pursue as the project manager directly, Paul Andrew. However, the company is vicariously responsible for the actions of the employees. The first condition to satisfy tort law concerns the defendant owing the plaintiff. The Venn diagram below illustrates the relationship between the Terminal 2E case and the Donahue v. Stevenson case. Similar to Mr. Stevenson, it was reasonably foreseeable that the failure to ensure safety in the development of the design and construction of the terminal would lead to harm to the occupants. Mrs. Donahue and the victims of the catastrophic events of Terminal 2E incurred physical losses as a result of the negligence of the defendant. Based on the decision from the Donahue v. Stevenson case, a court would likely find in favor of the plaintiff, the family of the victims of the collapse of Terminal 2E, given that the tort has been proven. Therefore, the family of the victims will be able to recover financial compensation for damages caused by ADPI.